of the 50 or so privileges in my state of Tennessee, all of them are administered administratively. All of them, these privileges, these occupations, state-owned occupations, are administered by civil process, except one. The one that's not is criminally enforced, and not by the state itself, but by the local latitudinarian constabulary, which the law indicates poaches upon the authority of the state to regulate the statewide privilege of driving and operating a motor vehicle. Why are traffic allegations criminal, and why are they not ever handled by the state itself, even though these cases are filed criminally against the traveler in the name of the state? Well, that's because this occupation is influenced by slave days and Reconstruction days, and the decision that came in 1857, Dred Scott v. Sanford, by Justice Roger Taney. Taney explains the pass system. The pass system controls today. It controls the entire use of the public right-of-way. The public right-of-way should be usable and used freely for pleasure, for private purposes, for the enjoyment and exercise of rights by each member of the public. Each citizen has these rights. However, the right of free movement, of enjoyment of ingress and egress rights from your abode, going and coming from your house, are everywhere abrogated. They're abrogated in Tennessee. And the answer is coming for your state, is coming out of our state, my state in Tennessee. And the answer is insisting on our rights to administrative hearings when an allegation is made against us for misuse of the privilege, for a harm done, unprofessional conduct done, wrongdoing done, violation of rules of the road done under the privilege, when in use of the privilege. Okay, so if we're in the privilege and we have a license, we have rights that we have never used before. And we've waived, until now, we have waived the right. We have yielded the right to be heard and make our defense in front of the commissioner, the state, not in front of a local criminal court. It's criminal court because the slave days live now. The slave catching patrols were the early police. The municipal police in the 1850s was to catch runaway slaves. Your municipal police department has slave day origins. And so the trapping of moving people, the chasing down of moving people, is from slave days that Taney defends in Dred Scott v. Sanford, and where he explains the pass system. The pass has to be there. Because think about it, he says, if the black were free to come and go as he pleased without a pass or permit, he would also be free to assemble. He would also be free to speak. He would also be free to bear arms. And these are not things that he was willing to entertain at that time. He was against those things. And so the pass system is a holdover, held over from slave days. I think if we recognize that, our indignation will rise, and we will find means, time, and occasion to fight back and resist. As numerous people are in Tennessee, Brenda Simpson, for one, the 76-year-old black lady jailed 2 months for traveling and convicted falsely by an ignorant jury, and Jay Hirsch and others. Follow me on this page.